Okay, we're recording now.
All right. Good evening, everybody. It's Conant Show, and today is April 11th, 2018. Going out a few minutes late, but that's okay. We're just tuning a few things up here to do a show, and while I'm starting out here, we're actually putting together content for a following show. So that's always kind of fun. So, well, yes, we still have some functionality problems with some of our equipment here. So we're having to improvise with all of our gifts and talents and computers and so on.
When one thing doesn't work, we work around to get it working another way.
Yeah, that's right.
That's cooperation.
Wait a minute. Okay, so it's hard to keep the banter going when I'm looking at this and that. So this next show that I'm assisting with here is about Waco, and I'm actually quite curious. Not to spill the beans on the show, but what aspect of Waco were you exploring in this show? The whole kind of story, or specific? The cover-up.
And very courageous FBI people coming forward now that they're retired.
Ah, yeah.
And chain of command issues.
This Waco was quite a thing. I remember among the last few times I saw a good friend of mine up along the St. Lawrence River, Donnie Sharrow, played guitars, and we're in a country band together for a few years, about 5 years. And I just happened to be in town, and it was dark. It was that time of year, and knocked on his door, and he opens the door and he says, "George, come on in, you got to see this." And I look at his TV, and his TV was kind of mounted high on the wall. He says, "They'll get anybody." Now Donnie's actually was a radio personality, a broadcaster from CKON, Mohawk Nation Radio, and he had quite the following up there. Anyway, he was very, aware of the media. Let's put it that way. And he started to just really lament for the people that were inside the compound as the buildings were burning. And I happened into his house as it was being broadcast live from the various news feeds that were out there at the site in Waco, Texas. And he said two things that really kind of stuck with me. And one is that he just says, pointing at the TV, goes, "See, they'll get anybody." And then he said, "George, we're all on the reservation now." And that kind of, I've heard that from other people a few times since. That phrase, "we're all on the reservation now," and which is a real good reason that you should learn your rights and know what they are, as the saying goes, and it might even be a maxim in law. I'm not sure, but he who does not know his rights has none. So that's kind of like the way the game that they like to play here. So learn your rights and know what they are, and exercise them. And I was just talking to my good friend and partner and lovely lady Laura Anson just really about an hour ago, not even, and I wanted to clarify something that I had went on about 2 shows ago, I think. And that is that, you know, as you all know, I've been updating everybody about the nature of the demise of the criminal case that was instigated against Laura by false charges made by Tai Burnette. And
It was a dismissal.
it was a dismissal in the interest of justice, which is a Clayton motion, and that refers to a man by the name of Clayton, who was a black man who served 25 years in jail, and the district attorney, I guess, figured out that they got the wrong guy, that he was in fact innocent, and they had gotten the wrong guy, and after 25 years he was released, and in the interest of justice. And so this particular kind of a dismissal is very powerful, because it basically is saying this should never have happened. Okay, I just want you to remember that. So Laura's adversary failed to get the system to convict her and further harm her, and but it's not over. There's still Tai has continued on with a civil suit that she started on Laura's birthday, 1 year into the criminal suit that she instigated on Laura's birthday in 2015, and then followed up being very unhappy with the progress of the judicial machinery, because there was no merit to the charges, and I can't explain this any clearer than a lot of statements were made that were not true to the police by Mary Kay Burnette, and in the end of the day, she ends up robbing Laura 1 day after having made the complaint on Laura's birthday, coincidentally. So there is this real malicious and mendacious attack that is now expressing itself as continued, slander in our community, and an obsession stalking Laura, really. Our neighbors have alerted us to people driving by and looking into our house and stuff over the past 3 years now, and coincidentally, only when we're not home. So that's another little bit of contention that we have regarding that. But what this all started tonight about is that 2 weeks ago I had read out some people's names that Tai, and I wasn't clear about this. These people were not accusing Laura of anything. It was Tai Burnette's, Mary Burnette. It was her claim that the following people were very much in her camp and wanting to testify on Tai's behalf against Laura. And these are people that Tai claims, I want to be very clear about that, Mary Burnette claims that these people are willing to go forward with testimony that they are missing property attributed and are attributing that to Laura. And so this is Josh Kroner, Kit Nato, Gail and Frank Duncan, Gabrielle Uvino, Katrina Lance, Amy Albert, Claudia Hirsch, Mary Leonard, Evelyn Pouget, Bob and Barbara Malkin, and Leanne Apina, among others. This is kind of the short list of all. These are all these people that, now some of these people actually are antagonists that are comprise a gang of sorts, and I know that personally, directly. But the others are either friends or employers or former employers of Laura's. And, you know, in all of the court action and documentation, none of these people have put forward any kind of signed complaint or affidavit of any kind, just so you know. But Tai claims that these people are very much, you know, in her camp and really gung-ho to go up against Laura. Yeah.
I would like to read something that we wrote on your and Laura's behalf. Could I do that?
Sure, go ahead.
Just because you sort of opened this up, that public access can be used as a public venue, so that, you know, if anything George and I are saying isn't true, you know, let people come forward with their signed and verified complaints. Now, what we did was Joe and I wrote this letter for the public record. It was from our address, 1610 Glasgow Turnpike, C2, Woodstock, New York, August 23rd, 2017. And I'm doing this because naming names is, it's also important to come forward when you know people to be people of virtue and stand up for them no matter what the momentum of slander against them might be, if you know certain facts. So this was written to the Honorable Victor G. Grossman. He was the Dutchess Supreme and County Court. That was the civil case. And that's 10 Market Street, Poughkeepsie, New York, 12601. Dear Judge Grossman, we would like you to take judicial notice of unsolicited, threatening emails from Mary Kay Burnette, a litigant in a case now before you, with our comments highlighted for your ease of reference. We don't know this woman personally, nor would we like to. We do know the opposing litigants, George Conant and Laura Anson, who are friends of ours. We are sending you copies of emails which have intruded into the quiet enjoyment and privacy of our email account by Mary Kay Burnette. We are also very concerned that all George Conant's paperwork have been thrown out, making this case, this court case, a one-sided argument which doesn't appear to us to be due process and equal protection. We did read where Mary Kay Burnett's attorney in his paperwork wanted all George Conant's arguments to be thrown out, but we never expected that a judge would take such a request seriously, clearly showing bias, and leads us to believe that George and Laura cannot get justice in your court. Please take judicial notice. And I want to say that since August 23rd, we've learned that judicial cognizance is a more powerful term. But still, judicial notice has plenty of case sites with it. Please take judicial notice that we consider these emails threatening and harassing, and ask this court to tell Mary Kay Burnette's lawyer to tell her we wish no further contact with her in any way, shape, or form. Joseph Barton signed the 24th of August, and Paula Gloria Barton also signed the 24th of August. Now, we also had two witnesses in the room when we were signing. So these two witnesses signed it. Carbon copies were sent to Bruce Rosen and Brian Rounds, so that, you know, this is not ex parte communication. And I also want to say that when I was looking to get it served, there was somebody who I expected would have done it, and she goes, "Oh, I don't want my name before any judge." And so I just say this to say it's very important when you know something to say something, and to not be complaining about, oh, the system, if you're not standing up for people who you know to be worthy to stand up for. So 5 people put their names. One was Steve Hamburger for the proof of service, to say we stand behind these people, so that they can't run those kind of legal fictitious games where, it seems Mary Kay Burnette seems very adept at and spreading innuendo and slander.
Yeah.
So I just wanted to speak that out since we're naming names now.
Yeah. I've really been quite cautious over the past 2 years in terms of divulging too much information as the criminal case was proceeding. And now we've had a crushing victory, I would say, for the opposition, Team Burnette. Didn't get her way that way. And so now in the civil matter that she's taken against us, she has continued to her pattern of threatening emails. And the most recent of which was to Laura's parents, which is, something that she actually does almost like seasonally at this point. It had been pretty frequent, like every couple of months, or maybe once or twice a month or something like that, and then it kind of fizzled out for a while. But I guess my last bit of paperwork really got her going. So much so that the last bit of paperwork that Laura and I put in which was a response to a motion for leave to amend and augment and amend their complaint and to re-argue this aspect of the complaint, which had already been dismissed by Judge Grossman, which in our opinion, of course, was the correct thing to do. He should have dismissed all of it, but he should have done a lot of things, but he's no longer in the game. We now have Justice Christy Acker, who is now hearing this case. Now, what I was heading towards was the pattern of threatening people with emails. And most offensive of all of this, and really obscene in my mind, is Burnette's continued contact with Hugo and Judith Anson. And it's really, really horribly inappropriate and taunting and threatening and slanderous as well. Now, I can pull that email exchange up, but it kind of gets even better. This last one is really over the top, folks. I mean, what litigant would send her opposing team, however you want to call this, her adversary? What litigant would send the adversary a communication between the litigant and her lawyer? I mean, this is beyond ridiculous. And she sent this with the court documents that Laura and I had submitted in answer to their motion for re-arguing conversion in as attachments with this email that she sent also as a forwarded email from her lawyer to Laura's parents, which of course is going to come to us, which it did. And so now we have to really, this is a question I'd like to put out to you, Paul. Do you think this is premature or immature or
definitely not immature or premature. And this is something we can really use community television for, to communicate to our community these deceptive practices. The first time I saw this was from one of the top attorneys, Shapiro, DeCaro, and Barak. It's a top law firm, and it's very much involved in the huge underground, multi-gazillion-dollar foreclosure industry, where this lawyer, DiCaro, actually has the nerve to tell a Supreme Court judge that his firm is behind the non-judicial foreclosure, which is illegal in New York. Now, why would a lawyer put his name to that? Because he was sending a courtesy copy to me. He took that risk because it was a threat, George. It was a threat.
Well,
you know what I'm saying?
It is
They
a threat.
took a risk. They took a risk to put something pen to paper. You know, it's black ink on white paper. We've got the hard copy of it, and that's why Joe and I are reopening the whole case, because most people, after they go through this exhausting process of due process, where you don't really get due process, it's just shored up by so-called police, but really rogue elements of police who are not following their oaths of office, to brutalize, terrorize, and harass and torment you, so that you have no energy left to retaliate. But somehow we have energy left, to do that. So now this was supposed to be between the lawyer and the judge, and I saw so many instances of this where clerks were making appointments with people who weren't even showing up in court. So it's to intimidate. It's to say, look how much power I have. I can do something like this. I think you should explain again exactly what it was that was done, and how strange that is to be writing something that appears to be something in private, but clearly leaked out, so that it's known in such a way that it threatens and intimidates. Because if you give the content of it, it's probably more understandable. By the way, there's not much light here because there's not much light here.
yeah.
We
You want me
used to have light.
Want me to turn one of them over to you?
No, it's okay. It's okay. But
You
even those
actually
are
look-
those are shrimpy lights.
The light
too.
actually doesn't look bad on screen for you, but
Okay,
I'm
good.
really well lit over
Okay,
here.
good.
All right, so I guess I look at this camera for now.
Yeah. But
All right, so
really,
my question to you,
read
Paula,
read the content of that email, though, because it was,
the one from the lawyer,
yeah,
as well as from Tai.
yeah.
And all right, I can't do that just yet.
Okay.
The shows are downloading.
Oh, okay.
The Waco shows are downloading right now onto a thumb
Thank
drive
you.
for you.
Thank you, George.
Well, so I'm getting a yes. Read it out, because this is a communication from our adversary, between our adversary Tai Burnette and her lawyer Bruce Rosen, and who works under him, this guy Oliverio, and you answered my question already, which was, is this inappropriate to do? But I guess to follow through on that thought, that's no longer a private email. All right, just to be clear, to educate everybody here, that's no longer a private email, because
Her choice.
it was Tai Burnette's choice to send it and forward it to Laura's parents in the effort to upset them, which it did.
Of course it did.
Mind you, because they're older and they're not in the best of health, and they've been wringing their hands and suffering stress over the fate of their daughter for 2.5+ years, and so any communication from Tai really upsets them, and Tai knows this.
George, any communication from Tai to anybody generally upsets them. We didn't like, that's why we wrote to Grossman.
Yeah.
Saying cease and desist.
So I just need a few more minutes here just for this thing to
Yeah,
finish its
yeah.
process. Otherwise, I might confuse the computer. And speaking of which, of computers and confused, I mean, just as a brief aside, this thing called artificial intelligence is really starting to spook me. My computer is actually making its own decisions from time to time, and it's really unnerving, because these computers are supposed to be machines and are supposed to do what they're told, not to do what they want. So it's kind of, this is a little bit of the world that we're
just a second, George, can I speak to that?
Yeah, go ahead, please.
Okay. I think that a lot of the problem is that the computer hardware, software, and that in-between firmware, because I've read all the license agreements. I've taken the time to read every single word. And it's not clear to me at all that when we buy a computer, we own the computer.
Yeah.
And if we don't own the computer, I think that opens up the possibility for other intelligences to come in and use this hardware, software, and firmware to make decisions. I don't think it's spooky. I think it's lack of privacy.
All right. So what we're going to do is I just realized that I'm not online here. So what I have to do is I have to switch seats with you for a minute.
Oh, you need to be online to get
or
these?
at least, so if you can just...
that's okay. You want to do it next week, and then I'll
No,
bring
it only
bring
take a
my
second,
Supreme
because
Court
I can
letter.
get online with the hard line here.
Oh, you want me to pull it up?
So if I get over there...
Okay. Here comes George.
Okay.
And here's a shout out to Rich Spool. He did a good job when he was here, and we wish we had Rich or somebody here back again so that we could get you a quality product.
There we go. All right.
This is great.
So we got a little musical chair action going on here.
Nice. I like it.
And
Innovative TV.
innovative TV, indeed. Okay, so let me just pull up a few things here. So Laura really is very, very strong in making it clear that Tai is really putting a lot of people out there in her emails, and I'm actually searching for the email where she names all these people. It's really such an affront when you see the lengths that this woman is going to.
Why don't you, I'll read my emails, okay? You want me to do that while you're pulling that up? And our comments? You want me to do that, George?
Okay, no, I'm there.
You're there, okay.
I'm there. And okay, so this is kind of a little bit of an introduction from Hugo, and because he doesn't know who to write it to, but he's framing his thought while he writes to us. So the subject is forward Burnette versus Anson and Conant, opposition to motion to amend. To whom it may concern, Hugo writes, email below provides further evidence of Tai Burnette's continuous email harassment and libelous remarks about our daughter, Laura. Burnette's obsessive, harassing emails, libel, and slander are beneath contempt. She has shown by her actions repeatedly and continuously that she is a sociopath, intent on spreading bad feeling and harm throughout Ulster County and in particular throughout the Woodstock community. I hope and trust that the civil court in New York State will impose justice and put a stop to this deeply unpleasant behavior. Hugo Anson, London, 9th of April, 2008. Begin forward message. From Tai Burnette to Judith Anson and Hugo Anson. Subject, forward, Burnette versus Anson and Conant, opposition to motion to amend. Your daughter is truly a sociopath, and I feel very badly for you. I will appeal at every turn until I prove my case, as she has stolen from and sabotaged so many people's lives. Best to you, Tai, sent from my phone. Begin forward message. From James Harry Oliverio at Mark Law to Tai Burnette, carbon copy, Bruce Rosen at Mark Law, subject, Burnette versus Anson and Conant, opposition to motion to amend. And let's see here. His name is James Harry Oliverio writes, Tai. Attached are Anson's and Conant's oppositions to our motion to amend the complaint. As you can see, they essentially rely upon the dismissal in the interest of justice. However, in our reply papers, we will be able to point out that the burden of proof in a criminal matter is higher than in a civil matter, a la the O.J. Simpson case, where the Browns and Goldmans were successful in their civil suit against O.J., even though he was found not guilty in the criminal matter. Accordingly, the dismissal in the interest of justice does not have res judicate effect on the civil conversion claim. Aside from that, it is a lot of the same song and dance that they have done in the past. Once we have a draft of our reply papers, we will forward to you for review before May 4th return date. Regards, J.H. James Harry Oliverio, McClusker, Anselmi, Rosen, and Carvelli, and they are the attorneys. So there you have it. So since I'm reading out their stuff, maybe I should read out my stuff.
Yeah, read out. And then if there's any slack, I would like to read a couple of these because it points out my big issue of privacy.
All right.
But you read your
we
stuff
got
first.
25 minutes, so
Yeah,
let me.
Yeah. This is exciting, George. Finally, I feel the ice is melting.
I don't really have permission to read Laura's out.
Okay, don't. then.
Should I not read Laura's out because I didn't ask her
No,
that?
no,
I didn't
don't-
tell her I was
don't.
going to do that.
No, we're all about permission, so.
So, all right.
Unless
we're
you want to
gonna-
call her up while I read mine
I-
out.
Well, since we're on this subject, let's stay with this subject and then we'll call her, or just we got plenty of time because this won't take long. All right, so this is my reply in opposition for motion to leave to amend complaint of 30 March 2018. Supreme Court of State of New York, County of Dutchess, Mary Burnette, plaintiff. Versus Laura Anson and George Conant, defendants and cross-complainants. This is my response, by the way. For those of you who want to look it up on the electronic e-file system, it's case... Excuse me.
Bless you.
That just snuck right up on me. Okay, the case index number is 2016-52818, and the general public can actually go in as a guest and look at the whole thing.
Oh, say that again more slowly. 2016
2016-52818.
52818.
Right.
That's 52818.
And you can go online and see my entire our entire case online in what they call NYSCEF, New York Courts e-filing. Right. All right, so it's NYSCEF. Let's see, New York State, I guess NYSCEF. No, it's NYCEF, I think. Well, it comes up if you put it in a search engine, it comes right up. And just scroll through the different options. You'll find guest and go in as a guest, and you can look at anybody's case because it's public record, right?
Right.
All right, so this is public record. And I write, reply in opposition to plaintiff's motion for leave to re-argue conversion. 7th of April, 2018, Your Honor. Maxim of law. Truth and fact are sovereign in law. For the lawyers to tell us that truth and facts do not matter in, quote, the real world, end quote, meaning in court, it is an attempt to deny us the right to due process and equal protection and to prohibit getting truth and facts on the record. Mr. Rosen has repeatedly stated as fact that Laura Anson was charged with theft. This is deliberate and intended to prejudice the court against Laura Anson. Laura Anson was not charged with theft, and Mr. Rosen's repeating this false statement equals fraud upon the court. I have documented from the beginning of this case why Ms. Burnett's claims are fraudulent and that this fraud is knowingly presented to the court by Mr. Rosen. Clean Hands Doctrine. Under Clean Hands Doctrine, equity will not grant relief to a party who, as actor, seeks to set judicial machinery in motion and obtain some remedy if such party in his prior conduct has violated conscience or good faith or other equitable principle. Franklin versus Franklin, 365, I think that's Missouri, 442, and other numbers. So that's how you can look that one up. Your Honor, Mr. Rosen is knowingly representing fraud. This latest motion to amend and re-argue conversion is both a shock and completely is meritless. This latest claim of conversion is yet another work of fiction on the part of the plaintiff. No stolen property was found in our home, as demonstrated by Judge Lamb's dismissal. Plaintiff has robbed my partner Laura Anson in our home. Plaintiff contacted Laura Anson's clients and defamed and slandered Laura Anson intentionally to harm Laura. This suit should be dismissed with prejudice against Plaintiff Burnette on the grounds of fraud upon the court. Mr. Rosen is knowingly representing this fraud. U.S. Code, Title 18, Part 1, Chapter 1, Sections 418, U.S. Code, Sections 4, misprison of felony. Whoever, having knowledge of the actual commission of a felony cognizable by a court of the United States, conceals and does not, as soon as possible, make known the same to some judge or other person in civil or military authority under the United States, shall be fined under this title or imprisoned not more than 3 years or both. And then there's a listing of all the numbers that this statutes are coming from, and codes, actually. Judge Grossman has erred by dismissing my affidavits and claims. Laura Anson was cleared of charges in the January 8, 2018 order and decision by Judge Lamb, who dismissed the charges of criminal possession of stolen property in the interest of justice. Judge Lamb examined the case for 2 years and dismissed it because the charges did not have merit. There was no evidence. There was no police investigation, only hearsay and allegation. So long as no one will hold Ms. Burnette accountable for making a false sworn complaint, the robbery of Laura Anson, or the false arrest that followed, then Ms. Burnette's criminal actions and fraud continue. Ms. Burnette has used law enforcement and judicial machinery to commit robbery and harm Laura Anson irreparably in the press without any accountability. Mr. Rosen has been informed by my first affidavit and second affidavit of truth and fact that has to this day not been rebutted with a counter affidavit by Plaintiff Burnette. Plaintiff Mary K. Burnette's criminal actions are detailed in the reporting that follows. Mr. Rosen has been informed of the criminal and malicious and ongoing attacks his client Mary K. Burnette inflicts upon Laura Anson and George Conant to continue harming Laura Anson and George Conant by using judicial machinery as a weapon and continued slander in our community. I am again informing all of the officers of this court that Mary K. Burnette has made a sworn complaint to the New York State Police that was false. It is a matter of record that Mary K. Burnette raided the home of Laura Anson and George Conant 24 November 2015 with two accomplices robbing Laura Anson of approximately $20,000 worth of Laura's property. Kitten Otto and Rita Pizarro are the accomplices who assisted Mary Burnette in the robbery, making this a robbery in the second degree, a felony. Shall I go on, or I got more?
Yeah.
Okay, we'll keep going. All right, this is a brief outline of our situation. 23 November 2015, Mary K. Burnette had made a complaint alleging that Laura Anson, my partner, was in possession of stolen property on November 23, 2015, to the New York State Police. 24 November 2015, Mary Burnette, Kitten Otto, and Rita Pizarro unlawfully entered our home at 73 Kate Yeager, Saugerties, New York. The three women held Laura captive in our home, accosted Laura, and Mary Burnette removed many articles of Laura's property while ranting and breaking things. She also smashed Laura's iPhone when Laura tried to call 911. I had just gone to Canada on business. Burnette claimed that Rita Pizarro and Kitten were police. Ms. Burnette had, she claimed, hired a private detective to find out who all our clients are. She did contact many of our clients and Laura's friends and family in the text message and phone conversations, telling all that Laura was a thief and much else to harm our business, which it did to some degree. Some people believed the story, many did not. We did lose customers. The most alarming thing, though, was the unfolding of conspiracy to deny due process and equal protection to Laura Anson, a property owner and taxpayer in Ulster County, by the deliberate, malicious, and criminal intent of Mary K. Burnette, who fabricated flimsy evidence, iPhone photos of objects, and had the assistance of several women to complain about Laura, a gang of sorts, to press the bogus criminal possession charges, resulting in an unlawful false arrest and subsequent legal costs and 2.5 years restricted freedom of movement. Lower court took Laura's passport until Judge Lamb finally dismissed the charges for wasting money and resources on a case that has no merit. As pleased as Laura and I am, Judge Lamb did right by Laura. Laura is still irreparably harmed by the police blotter and press releases in print and online, which was worded to lead the public to believe stolen property was found in our home by police. This never happened because Mary Burnette and accomplices had robbed Laura less than a day after Burnette made the false complaint. The day shortly after Ms. Burnette raided and robbed Laura, investigator Kinderman went to Ms. Burnette's home in Rhinebeck, New York, to follow up on the complaint. Ms. Burnette shows piles of stuff to Kinderman alleging it all came from our home. This is when and where the state police investigation should have stopped. The complainant cannot just raid the accused home and take carloads of property while holding the accused captive in her own home with 2 accomplices. No evidence Laura was in possession of alleged stolen property, but proof positive of Ms. Burnette's unlawful raid and seizure of Laura's property. Furthermore, Burnette, by doing this, has committed fraud, and Kinderman should have recognized this for what it was. Fraud, and is. Fraud equals a ruse, contaminated evidence, evidence tampering, robbery, and malicious abuse of law enforcement and judicial machinery to willfully and intentionally inflict harm upon Laura Anson. Laura and I went to the Saugerties Police, the Woodstock Police, the State Police, to complain, and we were told that because Mary Burnette complained first, they would not take our complaint. And now that dismissal in the interest of justice has happened, we are still being harmed by the police press release, which is a completely false statement and no apparent way to achieve redress. The State Police Troop F has recently deleted the press release. However, it can still be found on the internet. This is irreparable harm caused by Mary K. Burnette. Ulster County has probably spent $250,000 dragging Laura through the process, only to allow Ms. Burnette to ruin our lives, damage our business, and get away with robbing Laura of incalculable property because Burnette took so much and has had 2+ years to dispose of Laura's property. This happened in Ulster County. I want to know on what planet is this scenario lawful? Laura is irreparably harmed. I am harmed. Laura's parents have been harmed by this. I fear that anyone can just make false evidence and make a false complaint and have their neighbor arrested and ruined by the system with no consequences. Take judicial notice. Motions for leave to re-argue and or renew are governed by CPLR 2221. A motion to leave to re-argue and a motion for leave to renew must be specifically identified as such motion, CPLR 2221 and CPLR 2221E, Section 1. A combined motion for leave to re-argue and leave to renew must identify separately and support separately each item of relief sought, and the court decides each part of the motion as if it were separately made. A motion to renew is based on new facts and not presented in the prior application that would charge the prior decision and must contain a reasonable justification for failure to present such facts on the prior motion. The Second Department has repeatedly held that additional evidence offered on a motion to renew must be either newly discovered or have been unavailable to the movement at the time of the prior application. And this is more technical stuff about that. But the more important one, I'm going to skip ahead a little bit here in the interest of time. Take judicial notice. A motion to re-argue is not to be used as a means in which an unsuccessful party is permitted to argue again the same issues previously decided. Nor does it provide an unsuccessful party with a second opportunity to present new or different arguments from those originally asserted. And there's a lot of case law there. And then I write, Mr. Rosen's motion for leave to file an amended complaint pursuant to CPLR 3025 does not meet the criteria set forth by Rule 3025, as plaintiff is introducing new claims and there is no evidence to support plaintiff's original complaint, nor a new one. Defendants, cross-complainants, Anson and Conant, are taken by surprise by these new claims and that there is no evidence to support new claims. Also, Mr. Rosen has not filed the entire case history as required by Judge Grossman's order regarding filing new motions. Plaintiff's motion for leave to file an amended complaint should be dismissed. And then I also quote the rules that he was going under, Rule 3025, CPL Rule 3025, arguing a party may amend his pleading once without leave of court within 20 days of service. So there's timeliness issues involved. Again, there's more details about it. And then my final little statement here is plaintiff's motion for leave to file an amended complaint should be denied because it does not have merit and is absolutely a surprise. So that's one of the elements of 3025, CPLR 3025, is that if this is a sneak attack, a surprise attack on the other party, it's not permitted. This entire proceeding does not have jurisdiction and should be dismissed entirely because of fraud upon the court as represented by Mr. Rosen on behalf of plaintiff Mary Kay Burnette. I, George E. Conant, being older than 57 years old, do swear under penalty and pain of perjury I am telling the truth, the whole truth, and nothing but the truth. Signed, me.
Did you have that witnessed?
Witnessed? Yes, it was witnessed.
Okay. Do you want to ask Laura while I read this, or do you want to read more?
We only have 8 minutes.
Okay, read more. Or talk more.
Well,
I think it's exciting. I think something has broken. You know, I wouldn't have said as much as I did on camera because Joe and I were kind of following your lead, and you were constantly being threatened of slandering her.
well,
See what I mean? So we just, Joe and I always like to err on the side of caution.
well, so do I.
Yeah.
But I
know
think,
that.
but I think. But my feeling at this point, though, is that we have really kind of crossed the Rubicon here, where there's no turning back. Ms. Burnette has bombed this family, the Anson family, and by extension me, with her attacks and her pals, her little gang.
But other people too, George.
And other people. No,
Even our emails, she ruined the privacy and peace of our emails.
Yeah.
And most people think there's no remedy. You see?
Well,
I mean, obviously she's given a lot of pause and for reflection in a lot of people that you know. See what I mean? Oh, should we get involved and like that?
yeah. And this is what Ms. Burnette actually counts on. She counts on the fact that she is so good at harming people that she can intimidate an entire community
Yes.
to be silent in the face of damaging words, damaging actions, fraud upon the court. I mean, you name it, this woman will not relent in her intimidating of our witnesses, of our friends, of our family, in this really monomaniacal attack on Laura. She's stalking us. She's stalking Laura specifically, and the evidence is these emails that she sends all of her friends and clients. Tai Burnette has been emailing Laura's childhood friends in London to spread this slander. I mean, she's really over the top. So,
It's called sociopathic.
What's that?
Sociopathic behavior. You think, oh, sociopathic, it's such an extreme term. But it can be someone obviously highly intelligent, highly sophisticated, very persuasive. That's sociopathic behavior. It hurts the society. It hurts the community. That's why Joe was coming out about supporting Phil Voigt, with the Dharma bums, Phil Hemley, and for people to be writing letters. The more letters people write, the more you show judges and this so-called justice system, that you are a community, and that as a community you're healthy, and the community takes care of each other as long as people are upstanding in the community. If one person says harm is being done, then they should account for it. And there's remedies in law. It's called an affidavit of truth and fact. You swear to it. And you were giving those names before. They didn't swear to anything.
No, they didn't. In fact, there's a few things that we're a little curious about. One is a 30-page argument to take this to trial by ADA Swan that Laura's own lawyer, Brian Rounds, he refused to give her. Laura has a right to see that document. What was ADA Swan saying to Judge Lamb? We would like to know. There's a lot of other elements to this that are a little disturbing. That
like no ADA Swan, no Lamb, no Grossman, no Kinderman. They've all fled the scene.
What do you think? What do you think about that? I mean, I find that very, very strange. That seemingly all of the pertinent players, the ones that really do matter in this scenario, when it comes to officers of the court, they're just like disappearing by one method or another. I mean, what's your take on that?
My take is she's not just destroyed the Woodstock community of, regular people. She's obviously destroying a judicial system, wouldn't you say? She's used some kinds of persuasive abilities that sociopaths have. And Joe is always believing in the courts. He always says, Paula, don't give up on the courts. I always say, Joe, don't give up on the churches and synagogues, It's almost like what you put into something is what you're going to get out of it.
Yeah.
But this was one step, 5 people stood behind you. And right now, Joe's got 30 letters for Phil Helmley, so please write letters.
Yeah.
There was blank on the judge because he didn't know if it was going to go to Houston here in Woodstock or go up to Williams. But Joe doesn't think I'm right. I don't think Williams wants it. I think they're, pushing it back to stay here at Houston. So let's knock it out. Let's get justice.
All right. So, you were at the courtroom, and did you hear the level of the charges? I know the bail was posted at $20,000.
Yeah. I was there, but we came late. I have to.
Oh, okay, all right.
Admit. All right. We thought it was 5:00, and I think it probably started at 4. But I don't think the community is still very solid about what urgent is and what urgent's doing. I think that's really at the basis of it. You've got lower and lower rungs of these gangsters, and urgent is a pretty low level of gangster. And and so Joe, I think, is part of his healing process because it obviously causes post-traumatic stress. Joe, you can talk about what Laura went through for 2.5 years when her house was vandalized, and no due process, and nobody in positions of authority listening, correctly. It was the same thing for Joe in 2008 when they came in and trashed his place. But only recently has it been the right time for Joe to come before you. I think it was a couple of weeks ago. And he put the pictures up so you could just see what happened to his place. And, different towns, municipalities are signing on with urgent because they want a part of the cut. But, much better to have a community that's working by law and order and due process so that people who create, wealth, they have access to the fruits of their labor, and you don't have this very sophisticated system of theft, because it takes a couple things. It takes sneaky moves in courts, color of law courts, and then it also takes the knockout teams. When we were in housing court, Joe's always good at getting things on the record. He said, "Your Honor, are these men here to intimidate us?" They had big, hefty policemen, showing off their guns. And I think when one judge recused herself, we were shuffled over into another courtroom. We really should have been reserved. But I have a feeling that if we resisted doing it, they would have pushed anyway. I mean, we've got the transcripts now, almost $2,000 worth of transcripts, and it's going to be fascinating.
That's great.
Yeah.
So we're down to our last 90 seconds.
Okay.
And I'd really like to.
This is your camera.
Well, I put it to that one though, but I can go to this one. I can go to that one. It's all right. So anyway, the idea is that we got to stay on the system here to do the right thing, and find out what your rights are, and then you got to vocalize them. And yes, Laura and her family have been traumatized by the system, but that was put in motion by Tai Burnette. So I'm not going to get off that song and dance, as Oliverio likes to put it, because it doesn't change, whereas Tai's story keeps changing, and so does her complaint, because she can't get any traction. So let's see here. We got.
There's one good thing about Tai Burnette, what she's done. She's, by starting this show, let's keep doing this next week. Let's do more of this.
Sure.
Let's get permission from Laura, and I'll start bringing out some real juicy documents, not just Tai Burnette, but what you were saying. Grossman left, Judge Lamb, there's no death certificate, but he's gone. Then
Kinderman's reassigned, and Swan's not on the Ulster County list anymore as a DA.
Right. So, oh boy, I've got some documents to share along those lines, and maybe we can, George, maybe we can clean up this town.
Yeah.
And the whole city, the whole state and the country.
Yeah, well, maybe. All right. So we've done our 58 minutes, and I'm going to be signing off now. I'd like to thank you all for tuning in and watching and listening to our story here. And tune in next week, and we'll have another show for you. All right. Stay tuned for Waco. We got to do a little shifting here. All right. Thanks, everybody.